call, and then I will prompt for questions, okay? So who wants to take us through the issue spotting on call 1? Anybody?
I'll do it.
I can't see the whole class. Oh, Chris, you want to take it? All right, let's go. So the way that I would like you to please do this is to walk me through the headings, and then we're going to stop at the issues and we're going to discuss whether or not they're met. Now, I will say there are 21 IRACs in this essay. We can start talking about a little timing as well as we're going through it. I will also say that there are 11 major issues and 10 minor issues for the most part, give or take. I kind of gave a little summation on some of them. All right, so let's walk through how you would have written this pursuant to your issue spotting. So walk me through my first heading here, please.
Fifth Amendment. I start off with Fifth Amendment Miranda just for the
so
sake of.
let's make it specific to party names.
Oh, okay, sorry.
That's no, sorry.
Oh.
You're good.
Dan, Fifth Amendment Miranda.
How about Dan excluded statement under Miranda? Okay, I just modified that a little bit. Okay, good. So right away, getting into it. My computer is being a little weird, but this should all be left margin, okay? We have a little intro, right? And then what are our elements? Now, actually, I'm sorry. Let's talk about intros for a moment. Intros are not mandatory, okay? I give the intros because it's a nice setup. If you have time for an intro, great. But you can skip the intros. You can go right to the nuts and bolts of the elements, just as a rule of thumb. Okay, so where do we go from here?
We determine custody and interrogation as our.
So are these separate headings?
Yes.
Okay, good. So before you go to interrogation, we're going to go one by one, okay? So custody, what's the rule for custody?
An individual is in custody when they believe they're not free to leave.
Criminal defendant is in custody when he or she is
not free to leave.
Not free to leave. Okay, I'm not going to write the rules for today's purposes, but that's the rule. Now, was this a major or a minor issue?
I mean, I would say it's a minor issue.
Okay, why?
Going based off the idea that he's already been arraigned after they interrogate him.
Because it's very easily met pursuant to the facts, right? It's not a very meaty analysis.
Yeah.
So this is a minor issue, right? And in minor issues, we spend how much time on when we're writing, ideally? What's our time bracket?
2 to 3 minutes.
1 to 2 minutes.
Oh, okay.
1 to 2 minutes, ideally, on just giving the rule. Here, he was in jail. He was in jail, right? So therefore, he's not free to leave, and that's it. Okay, good. Next heading.
Interrogation.
Okay. Is this a major or minor issue here?
Major, in maybe not in the fifth sense, but maybe sixth. But
no, wait, let's not even worry about the sixth right now.
Okay, so I would say minor.
Okay, what's the rule here? I'm not saying that you're right yet. What's the rule here?
An interrogation is any conduct that the police knew or should have known would elicit a damaging or harmful response.
Good, incriminating response. Okay, and it's a subjective view, right? In the mind of whom?
Of the defendant. Or no, the police officers, the prosecution.
Correct. The police.
The police.
That are eliciting that statement. They're trying to get that statement. Okay. So in this instance, do we have an interrogation? Who's doing the questioning?
The informant.
So we would have given a general rule here, like you just said. I don't know why that's underlining, but whatever. And then we would have given we would have concluded, however, there is a sub issue on informants that is relevant for this discussion. And I would have done a heading, informant rule, or informants, either or. Okay, what is the rule for informants? This is the one that's going to apply, right?
Yes. I Actually, I just issue spotted, so I don't know the rule verbatim, but
Okay.
it's something along the lines as if the police had the informant go in with the reason to get illicit information, something along those lines.
Um, anyone else want to contribute to this rule?
Recording.
Whoever that is, please mute yourself, or I'll have to mute everyone but Chris. Sorry, I know voice. Okay. Okay. I'm like sound support right now. That was actually kind of cool though. Okay. That was a horrible like mixing thing. I don't know what I'm doing. All right, Chris, hold on. I'm going to find you here and I will unmute you.
Oh, I muted myself.
Okay, great. All right. So you can unmute yourself if that's, I don't want to embarrass anybody. If that's not your sound mixing going on, whatever that is, then fix that. Okay, informant rule. Well, the informant rule is whether the defendant knew that the informant was working for the police. That is the informant rule. If they don't know, then the coercion level is quite low, and therefore there will be no interrogation. What happened here? Did the defendant know that Sid was working for the government?
No.
No. Did not know that he was working for the government. This is a sub-issue that likely could be missed. I guarantee you with this bar, this was a highly missed issue for those that did not pass this essay, okay? So make sure you know the informant rule. So no coercion. I'll just do a little, I'm not gonna write the whole essay, okay? We just issue spotting here, thus no interrogation. Okay, underlying conclusion, Chris, you're doing so well. What's the underlying conclusion here?
No, no interrogation.
Well,
Or
that's
there was no
remember,
custodial, yeah.
Underlying conclusion is for the call of question. The call of question is his statement under Miranda, okay? So no interrogation under the informant rule. And then the underlying conclusion is the statement will or will not be excluded under the fifth.
Will not be excluded.
Not barred.
I do have a question. I did.
Hold on.
Oh.
Okay, are there any other issues coming up here? Are we done with this call?
I noticed deliberate elicitation possibly. But would that come up under the 6th?
Deliberate elicitation comes up under the 14th when we're dealing with pretrial identifications. It does not come up here.
Okay,
it's not an element here. Okay.
Gotcha.
All right. Right to counsel. Number 2. Who wants to take this one on? Good job, Chris.
Thank you.
Anyone want to take this one on? Do you think that we have the hold on. No one wants to take it? I can't see the whole class, so if you're raising your hand, I can't see you. You could just blurt out. Anyone? No one wants to take it? The whole class? Come on, don't be shy. We're training to be lawyers here. Let's go.
Can you hear me?
Who's that?
Kathleen.
Okay, Kathleen, thank you so much. So what's our heading here?
Sixth Amendment right to counsel?
Well, it's basically
Or Dan's right?
the same, yeah, the same as, we're just adding the word right to counsel here.
Dan's right to counsel?
Dan's excluded statement under right to counsel. Everyone can see my notes, right? The split screen, right? Thumbs up if you can see that. Yes? Okay, good. All right. So what is needed for the Sixth Amendment here? What is the crux issue, Kathleen?
Well, it has to attach. So I was thinking
Right, an attorney has to automatically attach, right?
Okay. Yeah, so I was thinking it attaches at his arraignment when he's charged with murder.
Okay. So if we have post-charge questioning and a confession comes out and there's no attorney present, is that excluded under the 6th?
Yes.
Correct. So here, the defendant was arraigned for murder, okay? And the informant, Sid, questioned him. Was there a lawyer there?
No.
No. Okay, so we're just analyzing this all here. The rule is going to be all about the attachment of the attorney. Does the criminal defendant need to assert their right to a lawyer here?
No.
Good. You're saying that like, no, I just know this. I love it. No. Confidence. I love it. Okay.
Well, the thing is, despite that it wasn't 30 years ago, I did clerk for somebody.
Oh, well,
Well, that doesn't
still
count.
remember it. That's great. Okay. So do we have a violation of the right to counsel?
Yes.
Do we have any waiver?
No.
All right. So we're not going to bring it up. Okay. So pursuant to the 6th, there is a violation because an attorney was not present during questioning. Just make sure. Okay, yeah. So are we done with call? Let me just go back up and see how the calls are laid out. Are we done with call 1?
I have a question, Shana. This is
Okay.
Latrice.
But hi, Latrice. But okay, I'm gonna ask you. Are we done with call 1? Are there any other issues going on here? Do we have offense specific for the 6th going on?
Did you put at the bottom, you just put down that it's the statement's excluded, right? Under the 6th.
Correct.
Okay.
Thank you, Kathleen. Good job. Yes, Latrice.
Would you bring up waiver with respect to the 5th Amendment, even though it doesn't apply, or did we not bring it up?
I would only bring up waiver if there was a waiver, if there are facts as to it. If not, it's a completely non-issue that you don't need to go into. You will see models that go into it just to negate it from the state bar, but I think that's a silly waste of time. Okay, you're not going to get points there. As a rule of thumb, when it comes to non-issues, and everybody will hit some of them as they're writing for these subjects. By the end of this training, and I really call it a training more than a prep, you should have such a great scope of issue spotting that you'll know your inkling, your intuition will know if it's at issue. But what happens if you're not sure? What happens if it's something on the fence? I want you to put it down, not spend a lot of time on it, quickly IRAC it and get out. That's the rule of thumb for this program, okay?
So I have
right.
a question, Shana.
Hold on, I don't know. Wait, hold on, let's go. Is there a raise of hand function on the screens? Because I can see those. Let's start doing that for questions, and then I can go one by one. Let's try it out. Someone raise their hand. Raise a hand. Anybody? No? Okay. Oh, there we go. Oh, I love it. Okay, let's go with Ginger first. I love it. It's much more organized. Okay.
Okay, so my question is under Miranda, like there's no facts. I guess I got a little confused. I was going into it, but there's no facts about whether he was read his rights. I mean, so to me, Miranda's, kind of was ruling it out. I mean, I was talking about it, but ruling it out is even an issue because it's post-charge. So I don't know how to,
remember,
there's no.
Okay, hold on. So we're talking about a confession, okay?
Right.
And so when you look at the call, there are different ways to challenge the confession. You're right. We don't need to have an attorney present under the 5th unless that would have been at issue if the facts said that the defendant at the time at the time of the arrest, requested his attorney. That would have been a violation of the Miranda potentially, but that was not at issue in this fact pattern. This was a confession, yes, made post charges, but the call is specifically asking for Miranda. It's asking for the 5th. So when it does that, it incites the need to discuss custody and interrogation. And that is how you challenge a confession under the 5th. Because remember, the defendant wants to use as many amendments as possible to them to go into a challenge to the confession that was made. I was watching 2020 all weekend. I'm obsessed with 2020, and I don't recommend it. Like, you might not be able to sleep, but I was seeing how some of these confession rooms look, right? And I thought about so many bar questions that could have been made and the way that the confessions potentially could have been challenged. But in any event, the key is just to know and utilize it as a rule of thumb. If they're asking about a challenge to a confession, if it's a general question, you go into all 4 challenges potentially. If it's a specific question like we have here, this is a specific call. It's asking for Miranda and right to counsel. Okay?
Okay.
All right. I believe the next, see, it raises hands and then it all goes away. Okay, Chris, what's your question?
The reason why I brought up the Sixth Amendment was because in the Long Island line, it states after judicial proceedings have begun, police may not deliberately elicit incriminating statements. So that's the reason why I had assumed that deliberate elicitation was under the Sixth.
Oh, yeah, but it's not an element
Oh, okay, okay.
that they cannot deliberately elicit, like they can't question.
Okay,
It's
cool.
part of the standard.
Gotcha. Thank you.
Okay, raise your hand again, please, if there's anyone I missed. No? Okay. All right, let's continue. Who wants to take on, I love the questions coming in. Who wants to take on call 2?
I guess I'll try it.
Who's that?
All right.
Who's that?
Martell.
All right, Marta, let's go. So where do we start? What's our heading?
Dan for first-degree murder.
Good. Okay. Is this felony murder?
No, I didn't include it as felony murder.
Tell me why, please.
The reason I didn't include it as felony murder, I didn't see him committing any type of, any other felonies other than just like wanting to kill.
Right. Okay, good. So there was no inherently dangerous enumerated felony first as that initial intent before the killing took place. Great. So let's go through and just hold questions while he gets through this, please. All right. Take it over. Let's go. What are my elements?
For first degree, an intentional killing.
Okay, so we got a specific intent. I'm going to stop you. Is this met pursuant to the facts? What happened here?
Pursuant to the facts, I believe that it was met because, he had a gun, under his jacket.
Who's he?
So, Dan.
Okay.
No, yeah, Dan had a gun on his jacket, anticipating that Vic was going to stab him. So, in order to prepare for that, he had his gun to protect himself, I guess.
And who started carrying the gun? Let's go back up to
Dan.
just so I'm
Dan.
correct too. After threatening Dan for several weeks, Vic backed Dan into an alley, showed him a knife, and said, "Think carefully about your decision. Your deadline is coming fast." Dan was terrified. He began carrying a gun for protection. Good. A week later, Dan saw Vic walking with his hand under his jacket. Afraid that Vic might be about to stab him, Dan shot and killed Vic. Okay, so we have this scenario now to keep going. Good.
Yeah.
So there is a specific intent. You are correct. You'd give a good analysis here, right? Like anytime there's intent, you really want to substantiate that intent.
Right.
With setting facts, ambiance facts. Okay, what about premeditation?
Did it in a time to reflect upon the kill? Mere moments
Great.
reflect.
How long does that reflection have to take place?
A second.
Good. You're on fire. Okay, what happened here?
After he saw that he might have stabbed him, he took his gun out and then he shot him. So at that moment, he had that premeditation to kill him.
Right, and then we want to add a major crucial fact here, right?
Yeah.
What is the crucial fact that we want to even say? Because we want to use as much premeditation facts as possible. What else? What else do we got? There's a key fact.
Was it the moment to reflect upon the killing?
Yeah, there's a key fact. You got it. Go back and look at the facts. Because this is going to bolster the analysis points, right? This is going to make your analysis points even better.
Oh, he started carrying the gun for protection.
For how long?
For like a week. So,
yeah, that's it. That's it. So my point is just let that be and make sure that's in your analysis. Okay, good. What's our next?
Deliberation.
Good. Okay. Was there deliberation here?
I didn't. This was a tricky one because I don't. You can argue that he did it in a cool and dispassionate manner, I guess it was calculated because he started carrying the gun for about a week. I guess you can say. So I think there could be an argument for deliberation, but I thought that was going to be a.
Was it deliberate in nature? What does your instinct say?
You said what now?
Was it deliberate in nature? Did he deliberately kill him?
No.
He didn't. Who
Well,
wants to back him up?
I guess he did.
I can.
Let's go, Latrice.
So he was afraid. Well, he saw Vic had his hand in his pocket. And then it says that he was afraid that Vic was about to stab him. So then he shot him. So I think those facts kind of support that it was deliberate, but it was in response to him having his hand in his pocket and being afraid.
Correct. Good job. All right. So yes, we have deliberation. Okay.
Shana, can I ask a question about that point? This
We're
is
going to
Shana.
round up the call and then I'll take questions. Okay. Just write it
Okay.
down for now. Martel. Okay. Where do you go from here?
Would you go to second degree after this? I believe you would.
What do we go to next after a charge? I would recommend going.
Any defenses. I'm sorry.
Good. I would recommend doing it here, doing a really good job with the defense, and then you can reference above when you keep circling back to it. I think that's a clean way to do it. Okay, what's our main defense here?
Self-defense.
Good. Okay, so what is required, the general requirement for self-defense?
Reasonable belief.
Reasonable belief of, well, it's not reasonable, it's imminent, right?
Right.
Okay, and it's an imminent belief that what's gonna happen?
That some type of harm is going to happen to you.
Not some type of harm, it's okay.
Bodily harm.
Deadly force.
Deadly force. Okay.
Right. Okay. So it's okay. Just a little on the rule there, but fantastic. So was there this imminent threat of deadly force here in this scenario?
He believed that he was going to stab him with the knife, which he did several weeks ago.
Okay. Let's go back to the facts. This is why I love this essay. Let's go back to the facts. Careful, careful, careful. Okay. And you're doing great, but this is why we do these exercises. So after threatening him for several weeks, he backs him into an alley, showing him a knife. And let's fast forward a little bit. He carries a gun for a week. That's the premeditation. A week later, Dan saw Vic walking with his hand under his jacket. Is that imminent? Did anything happen before the shot? Were there words exchanged? Was there anything to incite him or to make him think that he was right about to get killed? This is a tricky set of facts. And I do think that an analysis either way could give you a lot of credit. Okay, this is maybe one of those areas, because I think there is an argument to be made. And I think, Martel, this is where you're headed, where, yeah, it was a week, but I was still scared shitless. The person said, think carefully about my decision. My deadline's coming fast, right? But pursuant to the plain language of law here, it's an imminent threat of deadly force. And imminence is defined as immediate. It's not a week later. It's not a week later, okay? So pursuant to that three little words, a week later, there is no imminence here, and therefore self-defense is not a strong defense here. Major defense here, major defense. Does everybody see that? Yeah, okay. Now, is there a sub-defense here out of self-defense that could be discussed?
I said no, but I could be wrong.
Okay, now let's walk through this. Is there something in the long outline that you learned or in a lecture that I said when it backs up self-defense in a sense?
Imperfect.
Oh,
I wanted him to try, but that's okay. We can all help each other out. All good. Okay, imperfect self-defense. Okay, write that down. Highly tested when homicide comes up. It comes up on the MBE a lot as well. It's when a criminal defendant acts in good faith So it's not that imminent standard. And what it will do is it will not negate the killing, but it will bring murder down to voluntary manslaughter. Okay, so we'll bring either first or second degree common law down to voluntary manslaughter. So it will negate it. So as I said in the homicide lecture, anytime you see lesser included charge, you're thinking of the manslaughter charges, and you're also thinking of imperfect self-defense. Okay, that's a key defense. Everyone write down questions. I want to get through the issue spot and then I'll take questions. Okay, so great job, Myrtle, great job. Anyone want to, do you want to keep going, or anyone else want to take on? Let's actually go back to the call here for a moment. So we have, can Dan be convicted of murder or any lesser included offense? So we start with the highest charge, okay? This is a general question. This is one of those times where the approach fits in really nicely. You're not always going to get it like this, right? We wish we would always get something like this. This happens on your bar, you're going to be like, yes, but, well, hopefully, but, well, you will be, but just so you know, it doesn't always fit in this nicely. So we went through first. Now where do we go? I actually would have labeled this. Excuse me, I would have set this up a little differently. So 2, and I would have given a summation. Sorry. Just a little cleanup there. And then we go to our second charge. What's our second charge? Anyone want to take this on?
Second degree murder.
Second degree common law. Okay, I'm gonna take this on just because I want to get to your questions. We have act, causation. Okay, is there clear? We can all participate at once. Is there clearly an act?
Yes.
Yes.
Yes, there was an act of killing. Causation. Is there actual causation, Matt?
Yep.
Yes.
Okay. Are there any intervening forces?
Nope.
No.
Okay. So the quickly in and out. We'll go back to timing and after I'm done with this. All right. Where do we go next?
Malice.
Good. How many types of malice are there?
4.
Okay. Is
4.
this where the first 3 types of malice are at issue?
Yes.
Yes.
Yes, because we don't have felony murder. We're going to give some good cushion here, right? We already concluded above that there was, what am I doing? Sorry. That there was a specific intent. So is there an intent to kill then? Yes. Okay. Intent to inflict rape. I'm literally abbreviating. And then reckless disregard. Okay, so all 3 of these forms of malice right here need good RAC. This is a tendency of applicants sometimes here to be very conclusory and just quickly get out of each form of malice. Give some good cushion, pick up your analysis points, give context. You might be a little bit redundant, but remember that they're different standards, okay? They're different standards. So you wanna tie in and weave in the analytical posture with the key buzzwords of each one of these standards, okay? So we have an intent to kill. Do we have an intent to inflict great bodily injury? Yes. Do we have a reckless disregard? Yes, okay? What do you do with the defenses?
Same.
I would do the same thing and I would just abbreviate. As discussed above, self-defense is not at issue. And then I would go imperfect self-defense. Again, I would, don't forget, do not let your headings fall apart at this point. You still need to bring back in the consideration of the defense, okay? So you don't need to go into a full RAC, but short form it. That's that short form. We skip the rule and we just go into a little A plus C, analysis plus conclusion. Okay. Where do I go next? Someone tell me. Pursuant to our approach. We're in a general homicide question. They're asking for any lesser included offenses. We got to cover them all, right? We got to go down, down, down. So where do we go next?
Voluntary manslaughter.
Voluntary manslaughter.
Is this a major charge? who thinks that the analysis here is major for this one?
Would it be if the imperfect self-defense is used? Because it lowers it to like what?
Yeah, but that I'm saying for purposes of the elements of voluntary manslaughter.
Okay, no.
Well,
Yeah.
if hold on, if they cannot prove intent, could they at least prove provocation?
Yes.
Well, let's walk through it. Okay. So what is needed for provocation?
Intense passion.
What does that mean, intense passion? Intense passion, in what? Is it an objective standard?
Objective standard?
It's an objective standard in the mind of whom?
An ordinary person?
Good, good. It's an objective standard in the mind of an ordinary person. So I don't even know what that means, ordinary person, but would a person walking down the street, would they have been offended or would they have been provoked by this behavior? Yes or no?
Yeah.
You mean ordinary person as in a person that's already been threatened?
No,
Or
I
do you
don't think
mean-
it's a person that's already been threatened. I think it's just it's hard to define, but I think it's more just anybody. I think it's just us living in this scenario, okay? Because if you go back up to the facts, okay,
You can argue that an ordinary person would have been threatened.
in this scenario. So I guess, wait, to back it up, if the person, of course, if there's facts that that person was already threatened, fine. But I do think, like, for instance, if you're in a bar, okay, and somebody is sitting next to you and they make a joke about something, well, you have to kind of weigh it. Like, is this something that's only going to offend me, or would most people be offended by this? Okay, so that's how that ordinary standard is viewed. And when we're dealing with this set of facts, he says, okay, what if I was threatened or you were threatened like this? He threatened him for several weeks. He backs him into an alley. What happened before that? Dan's neighborhood was overrun by two gangs, the Reds and the Blues. Vic, one of the Reds, tried to recruit Dan to join his gang. He refuses. So in this scenario, I guess you could make the argument of somebody that's been recruited to join a gang. But at the same time, I think anyone would have been offended by somebody saying, if you don't join, your deadline's coming fast. Regardless, it's definitely a provocation, okay? There was definitely language of a provocation here, okay? Was he in fact provoked? Yes.
Yeah.
Going back down. Okay, this is a big one. Was there time to cool?
Shana.
Was there time to cool? Just I only want feedback on this element.
I mean,
No.
it says, oh.
Yeah, go ahead, Karen. Was that Karen?
Yeah, it just says afraid that Vic might be about to stab him. Is
Mm-hmm.
that considered time to cool? Like he had a moment to think about it, or no?
I don't think so. I don't think
No.
that's a relevant fact. For time to cool means like there was some real duration between the threat, the provocation, and the act.
Act.
So then no.
Huh? So then,
Saying-
well, what's the key? Give me facts, please. What's the key part of the analysis here?
It says Dan saw Vic walking in and with his hand under his jacket.
Back it up.
Oh, he began a week later. Dan saw
it.
Vic.
A week later. You had a week to cool off.
Oh,
Now, of course, at trial, this is going to be argued back and forth. Is a week sufficient time for somebody to be threatened and then really feel comfortable, right? But in essence, just based on the bare facts, okay, would there have been enough time to cool from that threat to the killing?
Yes.
Yes, I think it would side more on a week. If it was a day, it's relative, okay? So here's, we're seeing in this scenario, and this is why I absolutely love this essay, because it brings up kind of like Chris was getting at before, like, is there a right conclusion? But this brings up like, well, sometimes I think in this essay, you could have gotten a lot of points either way, but you had to be pretty straightforward with your analysis. So you didn't want to go off on a ledge here in the analytical posture. I would have argued that a week would have been enough time to cool here. And I also think it would have to do on the sufficiency and how aggressive the threat was here, right? So if we look at the plain language of the threat for purposes of analysis and being able to back up our charge and the element here, he says, he shows him a knife, think carefully about your decision, your deadline is coming fast. He does say he's terrified and he begins carrying the gun. I think the biggest problem that I have is the examiners, not me, but the examiners probably had with concluding that there was not enough time to cool, because I have seen both sides here, is that there's no additional fact after that week to incite that provocation again. There's no additional fact to say, and he threatened him again, right? I think if he would have just used some other language, we could have said that there was not time to cool, okay? So that's, but again, don't get caught up in the semantics of analysis. I'm gonna be working with you all on a personal level with that, but I do like the discussion of it, okay? Because hopefully it's getting your mind to understand more and more as we do these exercises, how your analysis should be going and in which direction, okay? In fact, cooled? No. Okay, so no voluntary manslaughter. No voluntary manslaughter. Are we bringing up self-defense here again?
Yes.
Good. Quickly in and out. Very quickly. Okay, are we going into involuntary manslaughter?
Yes.
Good. And which form?
Criminal negligence.
Great. What's the standard there?
Exceeds tort negligence, but lower than reckless disregard.
Mm-hmm. And there needs to be an awareness of the risk of death. So yes, there's an awareness here, right? There's an awareness, but is there a stronger argument for an intent to kill? Yeah, so
Yes.
Not a very strong charge. I wouldn't spend too much time here. It would be maybe a 2 to 3 minute Iraq, okay?
Would you make the argument for the significant minority of jurisdictions that lower it to involuntary manslaughter?
No.
Okay.
See, anything like that is just extra, maybe little brownie points if you have time.
Okay.
But remember, timing is something, this is a long essay. It's very long. There are 21 IRACs, okay? And I want to go through it for a moment. The Zoom is set to stop at 3. So I don't know if there's a way I can modify that from here, but hopefully I can get to all your questions. Okay, so I want to just say a few things here. So in all, I would give a summation. I'd say first, first, second, common law under intent to kill. Well, actually, no, I wouldn't even want to do that. Second, common law. In all, first, second degree common law is met. No voluntary manslaughter, I'm just abbreviating here. Obviously, you're not doing it like this. You're writing a full, nice, eloquent conclusion. Possibly involuntary, subject to the imperfect self-defense doctrine or defense.